Further hearing in the appeal of Jalla and another against Shell International Trading Shipping Company and another.
Yes, we'll go through.
The second point to which I was coming is the principle of control. That's what I want to turn to. We say the authorities consistently show that the hazard or the source of the nuisance must be located on land within the defendant's ownership or control, because liability and nuisance depends ultimately on the use of land. I want to turn first of all to Sedley Denfield, if I may. My Lords have it in mind, but it's a very important decision and therefore we should look at it. It's see the page number it is in the bundle Zoo Lodge was working with. 5184, my Lords. And of course, my Lords know the basic facts. There was a culvert on the Respondents' land, which was placed there by a third party, technically a trespasser, without the Respondents' knowledge. A grating had been put on the culvert, and that resulted in repeated blockages because it was not in the right place. It caused flooding. Now, the decision in our respectful submission of the House of Lords was that the respondents were liable on the basis that they, as landowners, had control of the land containing the blocked culvert and therefore the legal responsibility to abate the nuisance by unblocking or removing the culvert. Can we go to what Lord Wright said? I want to take my Lords to page 5207. After the reference to Cunard and Antiphire, a few lines down, his lordship says that the ground of responsibility that means in nuisance, is the possession and control of the land from which the nuisance proceeds. An important statement. Goes on to amplify that by referring to the Latin maxim in secutor tuo ut lanienum non laedas, which underlines that there's a property on both sides, I would suggest. But in any event, Dr. Blake will come back to that. The liability arises, in nuisance arises as a result of a person's control over the land that contains the hazard giving rise to the harm. That much is clear from Lord Wright's subsequent confirmation, and we see that on page 5208, top of the page, that the gist of the action is the unreasonable and unjustified interference by the defendant in the user of his land with the plaintiff's right to enjoy his property. And that underlines that there's an actionable nuisance where the defendant, or by himself or those for whom he's responsible, has created what constitutes a nuisance and it causes damage. That's also on the same page, but towards the end of the page. But Lord Wright went on to emphasise on the same page that the same principles apply where the defendant takes over the nuisance, ready-made, as it were, when he acquired the property, or the nuisance may be due to a latent defect or to the act of a trespasser or stranger. And he says the responsibility which attaches to the occupier because he has possession and control of the property cannot logically be limited to the mere creation of the nuisance.
If the claim in that case had been against the original trespasser, how do we read these observations of Lord Wright?
Well, first of all, we would say, I would respect it wouldn't be a claim in nuisance. It might be a claim in something else. But we would submit that the claim in nuisance is one that lies, as indeed this proposition states, against the occupier of land.
Could possibly be in negligence because of the fault.
Yeah. It could, of course, be in negligence because there's a negligent failure to site the culvert in the grating in the right place. All you'd have to do is see if there was a duty of care owed to the neighbouring landowner, and I actually would think that there would be, because he would be very much within the neighbourhood contemplation for duty of care cases. There might also be, though I haven't got to the bottom of this, there may also be, there's obviously a liability of the trespasser in trespass. Whether that would cover a liability to the adjoining landowner, I haven't yet discovered. I don't know how far the tort of trespass would go. But duty of care in nuisance, in negligence, will do it. What it is not is a claim in nuisance, in our respectful submission.
I mean, I have to say that is contrary to my understanding that the creator of the nuisance is always liable in nuisance.
Well, he may be liable. Well, not in nuisance, my lord.
No, liable in nuisance.
If the owner of the land creates it.
But, my lord, if the owner of the land creates it, of course, that's right.
Yes, but even the trespasser. Yeah, I think, well, we're just going to disagree, I think, because you're saying the trespasser would not be liable in private nuisance. My understanding has always been that the trespasser would be liable in private nuisance.
I don't know. My lord may have in mind a particular case which says that.
Well, Lord Holt's quite a good starting point.
My lord?
Lord Holt's dictum.
Lord Holt. I have to remind myself precise words.
I forget the name of the case, but which is almost precisely to that effect, although it's only reported in a later case, because in the report of the case it's not there.
My lord's right.
The name.
Roswell and Pryor, my lord.
I'm so sorry.
Roswell and Pryor.
Yes.
If that's what we're talking about, I'll come to that. But it would not be a continuing nuisance, which is actually what we're concerned with here, principally.
Well, it might be.
How, my lord?
If the trespasser has set up a situation where water is continually flooding the land of the claimant, that would be a continuing trespass, a continuing nuisance.
Well, in my submission, no, because the trespasser is not in a position to abate that nuisance, because he's got no right to go onto the land to turn it off.
Well, that's your submission. What I'm suggesting to you is I'm not sure that's correct as a matter of law, because your starting point is that you have to have continuing control over the land, and that is the proposition
You have to have continuing control of the place where the nuisance is so that you can abate it. That's the reason.
If you're not the perpetrator. I think
I'm
what's
not
being put to you
accepting
is that that is a perfectly good reading of Sedley Dennerfield, which was a claim against somebody who wasn't the perpetrator.
Yes. Let me... Let me just continue with this, because I'm drawing a distinction, of course, between the original creation, the original act, and a continuation, because it's a continuation, the continuation of the tort that we're concerned with. Otherwise, there's no conceivable argument for saying that so many years after the spill, it can be that we are still liable in nuisance to the owners of the land in the Niger Delta. Let me try and make all this good. But certainly, what Lord Wright says, I would respectfully say, where he refers to the possession and control of the property, and I'm going to come on in a moment to what is said by Lord Atkin. Just putting to one side for a moment the precise position of the trespasser, it's certainly clear from this case that the responsibility attached to the occupier of the land because he's got possession and control of the land. That's what gives him responsibility, and that's key to understanding what happens in relation to continuation. And then when we get to Delaware, which we'll do in a few moments, I want to take you, my lords, to the speech of Lord Atkin before that. Whether or not the occupier creates the hazard, there's a duty in nuisance to remove the hazard. So may I invite my lords to turn to Lord Atkin? That's at page 5200, which is back a few pages. Can you find Holt is Thompson? And I want to draw attention to what is said at the bottom of the page. The legal position is not, I think, difficult to discover. For the purpose of ascertaining whether, as here, the plaintiff can establish a private nuisance, I think that nuisance is sufficiently designed as a wrongful interference with another's enjoyment of his land or premises by the use of land or premises either occupied or in some cases owned by oneself. The occupier or owner is not an insurer. There must be something more than the mere harm done to the neighbour's property to make the party responsible. Deliberate act or negligence is not an essential ingredient, but some degree of personal responsibility is required. We had this discussion yesterday with my learned friend, and that's connoted in my definition by the word use. And Lord Atkin goes on to say that the conception is implicit in all decisions which impose liability only where the defendant has caused or continued the nuisance.
And he eliminates caused by saying this isn't a case about an original creator of the nuisance.
What he goes on to say, in the passage we're about to read, is that there's no difference between causing or continuing. He says in terms of they are the same thing. Says if a man uses on premises something which he found there and which itself causes a nuisance by noise, vibration, smell or fumes, he is himself, in continuing to bring into existence the noise, vibration, etc., causing a nuisance. Continuing in this sense and causing are the same thing. Because it seems to me clear that if a man permits an offensive thing on his premises to continue to offend, that is, if he knows that it's operating offensively, is able to prevent it and omits to prevent it, he's permitting the nuisance to continue. In other words, he is continuing it. And I read that partly because of the distinction, artificial distinction, we respectfully suggest that my learned friend seeks to bring of saying there's a whole difference between causing a nuisance and continuing a nuisance. They are the same thing. It will arise in different circumstances. You cause it, well, you've caused it. If you continue it, you've adopted it or taken it over with knowledge allowing it to continue. I want to make 3 points, if I may, out of these passages. First of all, and I think my lords very well have this point, the nuisance is not just the harm on the claimant's side. Secondly, I submit, and it'll be followed on further by my learned friend Dr. Blake, responsibility in nuisance attaches to the defendant's use of its land, i.e. the harm to the claimant must arise as an act or omission by the defendant that relates to its land or premises within its control. That's why we actually do respect this as a matter of principle. A trespasser shouldn't be liable in nuisance. And thirdly, there's no difference in principle between creating a nuisance and continuing a nuisance. The defendant's either using his land in such a way as to give rise to an interference, or the defendant is allowing its land to be used in such a way as to give rise to an interference. And maybe special cases which Dr. Blake will deal with this afternoon which slightly extend that principle, I don't know. But the omission by the respondents in Sedley Denfield was to fail to unblock or remove the culvert. That omission was intrinsically linked to the defendant's control of the premises on which the hazard giving rise to harm was located. Now, I know my Lord Burrows said yesterday, raised the question of the trespasser, and I may have answered it, at least so far as I am able to, already today. But just to summarise, 2 points. If the ground of responsibility in nuisance is the ownership and control of land, as it appears from the passages we've been looking at, it's very difficult to see how the trespasser could be liable in nuisance. It's not the trespasser's land, he doesn't control it, he's not using it. Unless one has an extended definition of use for the purpose of placing the culvert. But what Sedley Denfield tells us, those two speeches, is the talks about the use of land. Second point, even if the trespasser could be liable for a single cause of action in nuisance, he couldn't be liable, in my respectful submission, for a continuing cause of action in nuisance. The reason it was a continuing cause of action in nuisance in Sedley Denfield was because the landowner, the defendant, was in a position to remove the nuisance, was in a position, but in fact, with knowledge, he continued the nuisance. He failed to take steps on his property to remove the source of the nuisance on his land, and so failed to abate the nuisance. And that gives rise to a continuing cause of action in nuisance for so long as the defendant permits the state of things on his land to continue.
So what would you say about leaving the trespasser to one side? What do you then say about your opponent's use of Rosewell and Pryor?
I will come to that, my lord. I'm not going to ignore that. I will going to come to that. But if your lordships will permit me, I'd like just to develop the submissions a bit before I get to that. In fact, the next case I did want to take my lords to is a case that I think we haven't looked at so far, which is Davey and Harrow Corporation, which is a trees case. Now, that you have at page 3450. Court of Appeal decision. I've got that in here. It's a tree root case. The defendant had trees on his property. The roots encroached onto the claimant's land, caused damage to the claimant's property. And the defendants argued that no action would lie unless it could be shown that the defendant, and that it had planted the offending trees. In other words, it had created the nuisance. And that was rejected. And so at 3461, Lord Goddard, Chief Justice Goddard, Lord Goddard, said that the nuisance consists in allowing the trees to encroach from the land of their owner into that of his neighbour. The owner must keep his trees in, just as he may not allow filth to escape from his premises onto that of his neighbour. So keep your trees in, keep your filth in. And to your property, don't let it encroach onto your neighbour's property, or else you'll be liable in nuisance. It's the control of land, and therefore the control of the nuisance, which gives rise to the liability. Interestingly, he expressly draws an analogy there between tree encroachment cases and escape cases. The principle is the same. Whether it's an encroachment or an escape case, the landowner must not allow a hazard to emanate from his land and cause harm to its neighbour. My lords, there may of course be other bases for liability, but we're dealing here with a property tort, and that's why the focus is on the property, the symmetry, as I said yesterday, I had a debate with my Lord Sales yesterday about symmetry, the give and take, the sicutere tuo non lidas alienum. In other words, it's looking at the way that the law regulates the relationship between neighbours.
Is thistledown an aspect of the reasonableness
Yes.
element of the cause of action?
Yes, my lord. And this is all about the control mechanism that there is. And that's the unifying concept, as Fern says, is reasonable use. A debate as to what reasonable use means.
Well, trees are planted by the authority, but the thistles may grow entirely naturally.
Yes.
The question then is to what extent you're obliged to cut them down.
Yes. You have to control your land so as not to allow the filth out, the tree roots out, or I would say the thistle down out. Can I then go quickly to Hunter and Canary Wharf, just on the same line, and that's at page 3908. So I really just want to refer to one passage in the speech of Lord Cook. I'm sorry, Lord Hope. Lord Cook's name is at the top of the page. Lord Hope of Craighead at page 3948, letter F. The function of the tort in the context of private nuisance is to control the activities of the owner or occupier of property within the boundaries of his own land, which may harm the interests of the owner or occupier of other land. That's what the tort is doing. Again, he must see to it that what happens on his land does not harm the interests of his neighbours. Another case which follows that line, we can look at it quickly, is Jones and Portsmouth County Council, which is at page 4001. That was another case about plane trees. We've added a lot to the jurisprudence of this country. And my lords, I think, fully understand, whether it was apparent before, how this operates. Trees grow, the foliage needs water, that causes the roots to grow underground. They suck the water out of the soil, and that is then what causes the desiccation and the consequential cracking. Paragraph 5 of Jones on page 4003, the findings of the judge in his judgment towards the end, there was a foreseeable risk of subsidence of nearby properties if the trees were allowed to desiccate the underlying soil, and the judge specifically held that there was a foreseeable risk that the trees in question, when allowed as they were to grow well over 10 metres in height, would desiccate the soil under the property during hot summers or prolonged dry weather. And the maintenance programme, just a few lines before that, in paragraph 5, the maintenance programme included the reduction of tree crowns, which was, to, I quote, to reduce the amount of growth the roots put on and the water uptake by the tree. Now, there's a similar discussion of root desiccation, or desiccation by roots, in Delaware, which I'll come to in a few moments. But going back to Jones, so there was a foreseeable risk that if the trees were allowed to grow over 10 metres in height, they would desiccate the soil under the property, and that could lead to consequential damage to the neighbour. And the main issue was whether the defendant could be liable in nuisance, notwithstanding that it was not the owner of the trees in this case. In his judgment, Lord Justice Dyson, and this is at page 4005, paragraph 10, do I need to read the summons? So just take it from the final sentence of paragraph 10. As Mr. Palmer puts it, the key to responsibility in the law of nuisance is the degree of control in law and or in fact exercised by the putative defendant over the thing or activity which has brought about the nuisance. In my view, the basis for the liability of an occupier for a nuisance on his land is not his occupation as such, rather it is that by virtue of his occupation, an occupier usually has it in his power to take the measures that are necessary to prevent or eliminate the nuisance. He has sufficient control over the hazard which constitutes the nuisance for it to be reasonable to make him liable for the foreseeable consequences of his failure to exercise that control so as to remove the hazard. Similarly, control lies at the heart of the liability of a non-occupying owner for liability. And that will take us to Roswell, but we'll come to that in a moment. But that's the point. It's the liability of the owner but non-occupier, which gives rise to the liability nuisance. Do I need to read the rest of that? I don't think I need to rest of the paragraph, but my lords may want to just skim through it. So the key to responsibility, which we saw that at 4005, is the degree of control in law or in fact exercised by the putative defendant over the thing or activity which has brought about the nuisance. At paragraph 11, he went a little bit further we've looked at this, it's because it's by virtue of his occupation that an occupier usually has it in his power to take the measures that are necessary to prevent or eliminate the nuisance. And the Court of Appeal concluded, paragraph 12, that the defendant was liable on the basis it had control over the trees pursuant to an agency agreement with the owner. In particular, the defendant had the right and duty to reduce the height of the trees so as to prevent damage to nearby properties. So there may be an obligation to abate, but only in relation to property under your control. And that's key to understanding some of the cases. So when I then go to illustrate that, go to Cambridge Water, because that shows that if the hazard passes beyond the defendant's control, there's no liability in nuisance. And that's expressly confirmed by Lord Gough of Cheveley in Cambridge Water. That's at page 3243, it starts. Now, my lords know it's important to understand the facts of this case because there's a concern about two escapes or two movements of the chemical, the PCE chemical, which was so damaging, which ultimately escaped into the land of the claimant. And foreseeability is only the reason why one of those was not an actionable nuisance. The lack of control, on the other hand, over the presence of that chemical at that point in the strata was the reason why there wasn't an actionable nuisance in relation to the further escape, even though it was foreseeable by that stage that that could cause the damage that the claimant eventually suffered. I need to show that good. So if we look, please, at starting at the internal page 269, which is 3248. So this is and I don't want to read it aloud, but my lords will see there is a discussion of the evolution of general awareness of the harm caused by this chemical PCE. We go to page 324. What? I'm looking for. Oh yes, that's what it is. Sorry. If we can go, please, to 3285, because it's true that the alleged ground of liability for the escape initially was rejected on the basis it wasn't foreseeable at that time that this chemical could escape and would cause this sort of damage. But we can go to 3285, please. I apologise, my lord. It's a problem dealing with different bundles. There we are. So page 3285, letter E. Turning to the facts of the present case, it's plain that at the time when PCE was brought onto ECL's land, it was in a big container, and indeed where it was used in the tanning process, nobody at ECL could reasonably have foreseen the resultant damage which occurred at CWC borehole at Sawston. So that's what I term the initial escape. That was not foreseeable. However, he goes on, there remains for consideration a point adumbrated in the course of argument, which is relevant to liability and nuisance as well as Rylance and Fletcher. It appears that in the present case, pools of neat PCE are still in existence at the base of the chalk aquifer, beneath ECL's premises. That's the defendant. And the escape of dissolved phase PCE from ECL's land is continuing to the present day. So obviously, foreseeability cannot be the answer to that, because by this stage it is known. On this basis, it can be argued that since it's become known that PCE, if it escapes, is capable of causing damage by rendering water available at boreholes unsaleable for domestic purposes, ECL could be held liable in nuisance or under the rule in Rylance and Fletcher. So the question is, what's the answer to that? And the answer is in the next paragraph, starting for my part. I do not consider that such an argument is well-founded. Here we are faced with a situation where the substance in question has so travelled down the drift and the chalk aquifer beneath ECL's premises that it has passed beyond the control of ECL. To impose strict liability on ECL in these circumstances, either as the creator of the nuisance or under the rule in Rylance and Fletcher, on the ground that it has subsequently become reasonably foreseeable that the PCE may, if it escapes, cause damages, appears to me to go beyond the scope of the regimes imposed under either of these two related heads of liability. This is because when ECL created the conditions which have ultimately led to the present state of affairs, whether by bringing the PCE in question onto its land or by retaining it there, or by using it in its tanning process, it could not possibly have foreseen that damage of the type now complained of might be caused thereby. Indeed, long before the relevant legislation came into force, the PCE had become irretrievably lost in the ground below. So part of the claim is rejected on the grounds that it wasn't foreseeable when it was brought onto the land of the defendant that it would cause that damage. But the additional argument that was raised, well, you know now, was rejected on the grounds that by that stage it's passed beyond the control of the defendant. It's plainly and clearly on the basis of lack of control. Control is the condition which prevents that being liable. And that's why I think in the courts below they emphasised that control question. And my learned friend, when he addressed this argument, sought to reject the relevance of that point by saying that the decision turned only on whether the harm was foreseeable at the time of what I've termed the initial escape. Your Lordships have seen from the judgment that's clearly not the way the case was decided. And I think I've made that point. And that's obviously, and I think my Lords also have this point clearly, at least what my submission is, that the duty to abate is therefore closely linked to the principle of control. And I think in the course of argument one of my Lords put to my learned friend, but they couldn't do anything about it at this stage. And that's factually in relation to the oil. It's passed beyond their control, by which we mean it's passed out of their control on their land. And the duty to abate is connected with that principle of control. I referred yesterday, I don't think I wanted to, well, unless your Lordships wish me to take time on taking your Lordships to the two authorities I mentioned then, Goldman and Hargrave, the flaming tree, or Leakey and National Trust, the mound of product that came from one land, separate land to another. It may be worth just, however, quickly looking at what Lord Justice Shaw said in Leakey in the Court of Appeal. That's page 4073.
Yeah.
My Lord, it's the passage between letters C and D. The underlying theory of this approach is the correlation of control and responsibility. As the owner of land is normally in the best position to obviate or to contain or to reduce the effect of nuisances arising naturally on his land, he should be primarily responsible for avoiding the consequence of such nuisances or for compensating those who suffer by their occurring. The principle is reflected in the judgment Justice McMullen in the New Zealand case of French and Auckland City Council. I don't think I need to read any more of that because it Sorry. It's also referred to in a case my lords haven't been referred to so far, which is the case of Minton Good. That is at 4983.
I think Lord Dyson refers to it in Portsmouth.
Yes.
Yeah.
Yes, he did.
That passage, in fact, you identified.
Yes.
Slightly below it.
Yes. And the point about Minton Good is there was a non-occupying landlord who was held liable for the wall, I think, collapsed.
I thought he was held not liable for the wall.
The non-occupying...
He was non-occupying and didn't have a right of access to the...
No. He did. It was held that he did have a right of access. It may have been implied.
Okay.
But my lord is on the point.
Yeah.
The important point was because, did he have control or not when it wasn't in occupation? And the answer was, well, actually he did, because he had an implied right to enter to do the work that was necessary. I think I've got that right. And this is relevant to Rosewell, which I will be coming to.
Did you have a bundle reference for Minton Good, just for our notes?
For
Minton.
Minton Good, yes. I've got 4983, but that may just... I'm just hoping that's right. Again.
Well, that is Minton Good.
It is right.
4975.
Thank you.
But the quote is 4983. And there's a concurring judgment. What I refer to is from Lord Justice Somerville. It's a concurring judgment by Lord Justice Denning, who found that owner-occupiers were in practice responsible. This is at page 4985. My lords may just want to turn it up. 4985. Where Lord Justice Denning said that owner-occupiers were in practice responsible for repairs, which means he has de facto control of the structure for the purpose of repairs and is therefore answerable in law for its condition. And interestingly, at that same page, towards the end of the page, he rejects the idea specifically that the liability of the owner to passers-by depends on the precise terms of the tenancy agreement between the owner and the tenant, that is to say, on whether he has expressly reserved a right to enter. It depends on the degree of control exercised by the owner in law or in fact. So even without an express reservation of a right to enter, the landlord had, in practice, in fact, the ability to do the work, and that's what rendered him liable. I want now to turn to, I will be coming back to Rosewell, I'm not leaving that, but I wanted to, before I do that, I want to do another couple of cases. Delaware Mansions. We say, respectfully, our interpretation of, or the appellant's interpretation of that case is wrong. Lord Justice Coulson was quite right in his judgment, where he said it's a completely different kind of case to the present situation. That's in paragraph 62 at page 213. Again, my lords know the facts. A plane tree, which the defendant highway authority allowed to remain on its land, despite being given ample warning of the damage it was causing and being told by structural engineers that they should remove it. We've got references at pages 3488 to 3489 to the facts to that effect. Now, Lord Cook the Lord Cook discusses the problem of desiccation at paragraph 6 and 7. He notes that the tree was allowed to develop a large crown. That's what then led to the desiccation. And he held that this was a continuing nuisance because, and this is at page 3496, there was a continuing omission on the defendant's land. The tree remained under the defendant's control at all times, in the same way that the plane trees in Jones remained under the defendant's. And it's that, and not the way my learned friends try to deal with the case, that gives rise to the liability. Now then, this nuisance was continuing, but the reason it was continuing we find at page 3497, and my Lord Kitchen, I put this to my learned friend, if my recollection is correct, yesterday. At page 3497, he notes at paragraph 33, it's agreed that if the plane tree had been removed, the need to underpin would have been removed, would have been avoided. On the other hand, the judge has found that once the council declined to remove the tree, the underpinning and piling costs were reasonably incurred.
34 is a bit curious because the damage seems to be attributable to the later failure, even though it may have occurred at an earlier stage. Sorry, that may seem a little bit muddled, but in terms of who is responsible for the damage, it does appear that the remedial works for which that failure to control rendered them responsible included the remedial work in respect of losses which had occurred beforehand.
This passage here. Yes, I think it's 30. I think it's 34 of the judgment. I may be wrong. Which is well, there's a reference there, which I'm not sure if this answers my Lord's question.
Even though there may be elements of hitherto unsatisfied pre-proprietorship damage or protection for the future.
Yes. But the key, I'm not sure, my Lord will know, but I'm not sure whether this contradicts the point I'm making, which is the liability was because of the control of the tree and how it could have been removed. It would have done away with the problem. It could also have been pruned. We know that too from the other cases. But either way, it's control of the tree which gives rise to the liability. And in this case, it's continuing liability because there's a continuing failure to deal with the tree.
Yes, I completely understand the submission.
I'm obliged, my Lord. Whether I've dealt with my Lord's point, I'm not sure, but at least I've...
It may be the particular point I'm asking you about wasn't the subject of argument or wasn't particularly contentious in the context of that case.
We've been unable to find where it's discussed in that way, so that maybe my Lord may be right, it wasn't put in that way. I think I can move. Well, in my submission, this is what Lord Justice Coulson understood well in his judgment, what the liability in Delaware was and why that was quite different from the present case. The appellants in their written case, and I think this is paragraph 105, say this is a perfect analogy. It's not at all. Here we had a single oil spill. We detected the spillage after several hours, terminated the loading operation. The oil spill stopped. That nuisance was abated. What we're then concerned with is remediation. That's quite different. The consequences are quite different. And the fundamental proposition we make, and in my submission, my learned friend hasn't shown at all how it could be different, is that not remedying damage which has been caused is not continuing the nuisance. You may be liable for it in damages. You may be liable for it in damages, but that doesn't mean you're continuing the nuisance. And we haven't looked at this. There's 3 overseas cases which in my respectful submission are helpful to my lords. If I can take them quickly but in chronological order. The first is a case called Carpenter and Texaco from Massachusetts. Interestingly, my learned friends in their case at paragraph 117, actually deal with the facts of this, but without realizing it was decided, because they say if oil leaked from a Shell petrol garage near London spilled over onto the surrounding community, it would be bizarre to suggest that once it left the forecourt, the oil was necessarily outside Shell's control. But these three cases demonstrate exactly that. And there's a confusion with respect, my learned friends, talking about the difference in clearing up and abating a nuisance. So Carpenter, which is at page 5575, facts were it's decided by the Supreme Judicial Court of Massachusetts, unanimously by 5 justices. The claimant sued the defendant owners of a petrol station for interference with its land by gasoline that had leaked out of an underground petrol storage tanks.
I'm so sorry, where are you reading from?
I'm actually summarising the facts. But I'll find where it is.
Don't worry.
That was the nature of the claim that was brought. But the leak had ceased over 3 years prior to the commencement of proceedings, 3 years being the relevant period of limitation. And the court dismissed the action on the grounds that it was time barred. And at page 5576, in paragraph 2 of the decision, of the opinion, with which all the other judges concurred, the plaintiffs argued that the continuing presence of the gasoline on their property is analogous to cases in which relief was granted because of the continued presence of an unauthorized structure erected on one man's land. The judge rightly rejected this argument because a continuing trespass or nuisance must be based on recurring tortious or unlawful conduct and is not established by the continuation of harm caused by previous but terminated tortious or unlawful conduct. And after citation of authority, the cases on which the plaintiffs rely concern not a single encroachment resulting in permanent harm, but rather repeated or recurrent wrongs involving new harm to property on each occasion. Now that's exactly in point, and we would invite my lords to find that helpful. The two other cases, the first is at page 5823, which is an Ohio decision. Again, this is Ohio Court of Appeals, unanimous judgment, panel of 3 justices. And natural gas and crude oil were released by the defendant, East Ohio Gas, onto the claimant's properties. They had not been remediated, those had not been remediated, and the claimants filed a federal action. The relevant cause of action is very similar to how we would formulate the tort here, continuing nuisance or trespass, and that's the argument. That's at paragraph 18, or 4, it's got both 4 and 18, but it's on page 5828. My lords will see what is said there. Continuing trespass or nuisance occurs when the defendant's tortious activity is ongoing, perpetually creating fresh violations. And then if we go over to page 5830, this puts it very shortly. In the present, the top of the page, on the left-hand column, in the present case, it appears East Ohio was responsible for only one tortious act, namely the leak that occurred in 1989. Although the leak allegedly left contaminants on the property, East Ohio did not have control over the property or the contaminants. Therefore, East Ohio is not liable for a continuing trespass. And then we go to nuisance at the end of the paragraph on the next column. On the right-hand column, starting at 32, the court continued, this language refers to a permanent trespass or nuisance for which but one action lies and for which damages may be awarded in solido. The appellant's first claim regarding nuisance can be disposed of in the same manner as their trespass claim. So it's the same reasoning. That's entirely consistent with our submissions here. And in And then the third case, I'm rattling through this a little bit, is a case from Canada, a case called ML Plaza Holdings and Imperial Oil, and it's at page 2006. 5773. Sorry.
Sorry, which was the page?
5773. I gave a wrong reference. I'm not sure why. Oh, I think it was in 2006. I gave the date wrong and the page number. My fault. In any event, my lords will see the case there, and it is, as my lords will see from the facts, about a service station on a shopping mall. And then, if we go to paragraph 9, on page 5776, it's clear from the chronology that any escape of hydrocarbons that contaminated the site must have occurred before the service station was closed and the tanks were removed in 1992. ML Plaza asserted, however, there was continuing damage by the expansion of the area of contamination by the movement of hydrocarbons through the soil underlying the mall beyond the service station leased site after that time. And the trial judge relied on the law of nuisance. On the facing page, she accepted that Eureka trial judge dealt with it at paragraph 72 of her judgment. I'm satisfied that all of these case authorities make it clear in the face of a limitation defence, the mere presence of contaminants in the soils or groundwater is not sufficient to found a claim for damages. And then on paragraph 13, on page 5778, on the facts here, there could be no further escape of hydrocarbons into the soil after the tanks were removed in 1992. In the context of the quote from Salmond, yes, I want to just, the quote that's now referred to, and perhaps I should have taken my lords, this is up towards the top of the page. Do our lords see there's a paragraph that starts, I adopt the proposition of law stated in Salmond on torts.
Yeah.
On the top of page 5778.
Yes. Yes.
And the statement is when the active defendant is a continuing injury, its continuance after the date of the first action is a new cause of action for which a second action can be brought. And so from time to time until the injury is discontinued. An injury is said to be a continuing one so long as it is still in the course of being committed and is not wholly past. Thus the wrong of false imprisonment continues so long as the plaintiff is kept in confinement. A nuisance continues so long as the state of things causing the nuisance is suffered by the defendant to remain upon his land. I draw attention to that. And a trespass upon the plaintiff's land. And then, if I go back to paragraph 13, bottom of the page, that there could be no further escape after the tanks were removed. So the state of nuisance, state of things causing the nuisance, has been removed. And that's understood to mean the activity causing the nuisance. And therefore the judge was right to say it was all out of time. So that's entirely consistent too. And what we suggest...
Yes, it's quite interesting. Just reading down, I realise it's very difficult to pick this up out of context. But if you look at paragraph 12, but I think they're probably citing from somewhere. Sorry, page 5778.
Yes.
Paragraph 12. There's reference there to succeeding for fresh damage resulting from the flooding of polluted water. The initial polluted water, where it's caused fresh damage, there's a new cause of action.
Yes, yes. I mean, without reading that decision, I'm not sure.
Yes, no,
precisely.
sorry.
The distinction that's being drawn in any event is that the court is saying, no, there's no. It's fast beyond. The state of things which caused the nuisance has come to an end. That's been removed, and so there's no continuing tort.
Well, from what one can tell from paragraph 12, it looks as though the situation was one in which there was further pollution.
That may be so, my lord.
We continued to operate the sewage lagoon and discharged polluted water onto the plaintiff's land.
I think my Lord is right, and that differs therefore from the facts of the case before the court, because...
And that fits with what's said in the next sentence, that the action succeeded only for fresh damage resulting from flooding within the limitation period. Damage resulting from earlier flooding was barred. So in other words, there is a continuous process
Yes.
of fresh flooding occurring.
Yes, and continuing torts causing that fresh flooding, we would respectfully say.
But at the end of paragraph 11, they seem to approve, as coming from the Darley Colliery case, the proposition that...
I'm coming to that now, my Lord.
That passage...
Well, I'm coming to the whole case.
No, but I'm just looking to see what they say about it.
Okay, my Lord, certainly. Of course.
That where... Oh, in fact, they're getting it from Dufferin, but they're getting it as a based on Darley. Where damage is the cause of action, or part of the cause of action.
Yes.
A statute of limitation runs from the date of the damage and not the act which caused the damage. If there be fresh damage within the statutory period, an action in respect to those damages will not be barred.
Well, I understand why that's said, my Lord.
Which takes one back to the discussion we were having yesterday about the fresh damage.
Well, that's right, my Lord, yes. And whether you therefore need, as my Lord the President was putting to me, whether you could in fact bring an action for all the damage, indeed including damage to come at that time. I think that's what's meant by a claim for the damages in solido, rather than having to do separate cause of action. Maybe in a given case there may be some nicety in the facts as to which it is. What these cases show, we say very clearly, is that firstly, a continuing cause of action in nuisance requires a continuation or a repetition of the elements of the tort, not just of the consequences of the tort. And that if you're seeking to say that a defendant is liable for a continuing tort, you need to show that he continues to be in control of the place where the nuisance is on his land. In Salmon's language, the state of things, in control of the state of things, so they can bring it to an end, abate it. Okay. So Darley, I finally read. And my lords have dismantling the court, I'm afraid. It's very important in our submission really to try to one needs to read all the judgments and try and construct what actually is being said. And I want to do that by starting by asking my lords to go to Lord Fitzgerald's judgment. Because he sets up 4 propositions which, in my submission, help to understand what the case was about.
Page, please.
Page 3445.
Thank you.
And there, 3446, I think. Lord Fitzgerald sets out, starting just at the bottom of 3445, it sets out certain propositions, and it's important to understand those. And there are 4 propositions. First, that the owner of the surface has a natural and legal right to the undisturbed enjoyment of the surface in the absence of any binding agreement to the contrary. Secondly, that the owner of the subjacent minerals may excavate and remove them to the utmost extent, but should exercise that right so as not to disturb the lawful enjoyment of the owner of the surface. Thirdly, that the excavation and removal of the minerals does not per se constitute any actionable nuisance invasion of the right of the owner of the surface. Those subsequent events show that no adequate support has been left to support the surface, but, importantly, when in consequence of not leaving or providing sufficient supports, a disturbance of the surface takes place, that disturbance is an invasion of the right of the owner of the surface and constitutes his cause of action. That's critical in our submission to understanding this case, and indeed the dissent of Lord Blackburn. So if we could look then at the end of Lord Fitzgerald's judgment speech, and say, at page 3447, please. Yeah. 3447. There was an admission made, which is important to note, that after partial subsidence in 1868, the strata remained practically quiescent until the working of the coal in the next adjoining land by the owner thereof in the year 1881, which working caused a creep and further subsidence. But further, that if the owner of the adjoining land had not worked his coal, there would have been no further subsidence, and that if the coal under the respondent's land had not been taken out, or if the appellants had left sufficient support under the respondent's land, then the working of the adjoining owner would have done no harm. So the failure to leave the support was critical to the damage which then occurred. And what Lord Fitzgerald then goes on to say, it will be observed on these admissions that the partial subsidence of 1868 had practically ceased, and that a fresh creep and subsidence took place in 1882, which would not have taken place if the defendants had left sufficient natural support under the plaintiff's land, or we may add, had given artificial support. And then on the next page, toward the end of his speech, there's a reference to Backhouse and Bonamy, and it's just that it's really the paragraph which starts, there was a complete cause of action in 1868 in respect of which compensation was given, but there was a liability to further disturbance.
Oh, I've got it. It's 3449.
I'm sorry. Yes.
Yes. Okay.
Yes. There was a complete cause of action in 1868 in respect of which compensation was given, but there was a liability to further disturbance. Very important sentence follows. The defendants permitted the state of things to continue without taking any steps to prevent the occurrence of any fresh injury. A fresh subsidence took place, causing a new and further disturbance of the plaintiff's enjoyment, which gave him a new and distinct cause of action. It's that failure of support, that and his lordship goes on to say, if that view is correct, it follows if the cause of action now insisted on is not the same cause of action, but a new and independent cause of action. Well, I want to just continue reading this. Can we now go?
The analysis turns on the wrong being the disturbance of the invasion of the claimant's rights occurs when there is a disturbance of the surface.
Yes.
And when Lord Halsbury commented it out, puts it as the damage is the cause of action. And Lord Fitzgerald is saying almost the same, that it's the interference with, or it's the disturbance of the surface,
Yes,
which is the legal wrong, and therefore gives rise to the cause of action.
and importantly, because these cases have established, and no doubt this was important in Victorian England, that taking coal out is not a wrong.
Yeah.
It's something else, and what it is a failure to support. Take as much out as you like, take it all out. But then you have to support it, and if you don't support it, then there's not only a wrong, but it's a continuing wrong because you're not continuing.
Well, that's Lord Justice Bowen's reasoning in Court of Appeal, but it's not what Lord Fitzgerald is saying.
Well,
he's saying effectively, if you fail to support, then you take a risk that a cause of action may subsequently arise if there's a collapse.
but it's flowing from the continuing omission to provide the support.
I'd have thought that he's really making the point. You've taken all this coal out,
Yes.
And that is having an ongoing causative effect in 1882 with the second subsidence. And really, the fact of not putting in additional supports just makes the point that it's that original excavation which has that effect in 1882.
Yes.
And the interesting question would have been if the defendant had sold his seams.
Yes.
And the second subsidence had occurred after another owner had come onto the scene.
Well,
I mean, that didn't happen, but it would have been nice to know what the outcome would have been.
Well, my answer to that, had it happened, my lord, he would have been liable because the new owner would have had a similar obligation to support the surface.
I'm talking about the old owner.
Would the old owner have
As the original perpetrator, because he abstracted the minerals without leaving proper support.
Tire of land.
That's the problem.
well, possibly yes, if it was within time.
Well, no, I mean, that's the, if it was, the question is whether time starts to run when the subsidence
Well,
occurs.
Yes, I see my lord's point, and it does seem, because damage is a necessary part of the tort, you don't have a completed cause of action
There had
until you
been
have the damage.
previous subsidence, but this second subsidence was said to be a new damage.
Yes,
and
yes,
therefore,
I see the point.
the cause of action only complete when it occurred.
Yes, I see that.
The question which I would certainly welcome assistance on is how one distinguishes the new from the old,
Yes.
and how fine a distinction is it permissible to draw? When does it need to be a new interference with the property, or
I think
is it a
Lord Bramwell
consequence
may
of
help
the
us on
old
this.
interference and so forth? I mean, these I think
Yes.
may be pretty key.
Yes, well, I think Lord Bramwell may help us on this if we can go to
Well,
his
Lord
speech.
Bramwell has a different approach again. I mean, he blames it all on further coal mining. There's a different cause operating for the second incident of subsidence.
But that's what the admission of facts really showed us. There are actually three things that are happening. But let me take my lords to Bramwell. I know my lords have seen it, but where do you want to go to?
It's perhaps also, I mean, given that it's another House of Lords case, when we're in Lord Fitzgerald on page, oh heavens, I can't read this, but he discusses Backhouse and Bonamy, which is another House of Lords case.
Yes, and that's
Right, thank you.
yes.
And he quotes, I mean, it's put in a nutshell, the thinking that he is following. We have Lord Westbury, 7 lines from the foot,
Yes.
telling us that when the enjoyment of the house is interfered with by the actual occurrence of the mischief, the cause of action then arises, and the action may then be maintained. And Lord Cranworth adds, it's been supposed that the right of a party whose land is interfered with is a right to what's called the pillars, or the support. In truth, his right is to the ordinary enjoyment of his land, and until that ordinary enjoyment is interfered with, there's nothing of which to complain.
Yes, exactly.
And I mean, that just reflects the fact that this is an action on the case, that you don't have a cause of action until you've suffered damage.
Yes. But but there needs to be the continuing failure for it to be a continuing tort.
Well, that's...
I know my Lord Briggs is shaking his head and disagreeing with me.
I'm just not sure you can get that out of Backhouse and Bonamy or Lord Fitzgerald's analysis of it.
You may be right if one's talking about a continuing nuisance requires there to be an ongoing failure to do something.
That's what I am trying to say.
But we were debating what was happening in Darley, and what was being put to you was that Darley was not analysed as a continuing nuisance case. It's analysed as two distinct
nuisances.
Sort of one-off nuisances. The first nuisance is when the first damage occurs in 1868. But what was significant about the admission of the facts was that it emerged that everything had settled down after that. So it was not possible to regard what happened later as a continuation of that damage. What then happens in 1882 is that there's a second event of damage.
Yes.
And then, on the theory of it being an action on the case, that's a second cause of action.
Yes.
So there isn't a continuity just to put it to you, and then you can say why I'm wrong. It didn't seem to me that reading the judgments in Dali that they were saying that there was a continuity of wrongfulness day in, day out. There was one wrongfulness, you'd taken all, well, to use a phrase, you'd taken out all the coal at the start. Nothing had been done to break the causative chain through to 1882. 1882 is new and separate damage from that, associated with that original action, the removal of the coal, and is a distinct and separate cause of action, different from that in 1868. But there are two, not a single continuing nuisance throughout, or a continuing cause of action day by day.
Well, I do see that. The significance from my point of view isn't really quite so much that. It's that there is a continuing failure to provide the support. And that is significant in 1882 because at that point, that failure of support has a causative effect, namely the land. There's no cause of action in relation to the 1882 subsidence until that happens, but it flows from, indeed as the agreement on facts had shown, a combination of events, a combination of things, one of which was the continuing failure to provide support.
Yeah, but it's the significance of that. I mean, well, as I read it, it seemed to me that the significance of the failure to provide support in the interim between 1868 and 1882 was just to establish that there was a continuing causative effect from the initial excavation.
Because the issue was not, is there a continuing tort, and therefore it didn't need to be considered. I accept that.
Can I just ask what the implication of that is? Because my understanding is that you are trying to meet a case based on continuing nuisance.
Yes.
Now, if it's said that Dali is not a case on continuing nuisance as such, does that mean it falls outside the ambit of what we're actually talking about?
Yes, in short.
Or does one say, well, the notion of a continuing nuisance is somewhat open to argument, and that this is at least very closely analogous because, as you just said, you may see it as a continuing failure to deal with one's premises, which has then caused two separate causes of action. What I'm really needing to know is, are you accepting that you've got to deal with Dali?
Well, I hope I've dealt with it, but I understand what my Lord is putting to me.
Maybe one way of looking at it is to ask whether proceedings could have been brought. I was about to say could have been brought before the second.
Well, my Lord, I was going to say,
substance.
Could proceedings have been brought for an injunction, for a quia temet injunction?
We don't know.
Yes.
That assumes that you could still get into these long disused seams and put up or put back support which you didn't put there properly in the first place.
Well, that's a question of a fact.
Well, if we just don't know what the answer is in Dali.
Well, we don't, but we do know this. We do know that it was the responsibility of the defendant, whose land it was, on which this problem was arising. The land being the seams of coal, and he created this problem by leaving insufficient support. And if the owner of the surface had gone to court and said, please make them do something, the court would have said, well, it's their responsibility because they've not left the support. Let's now look at what is possible. And maybe it was too late to get in to put in supports. Maybe it wasn't. I don't know. I mean, presumably if it's an operating coal, there'll still be a shaft at least that you can, assuming it's a deep mine rather than a...
I think, as I understand this, the way this case has proceeded, you don't deny that if on the first occasion when a particular landowner's land is affected by the oil, that starts a 6-year cause, or 5 years, the case may be, limitation period running, even though you had ceased to be in any blameworthy sense in default at an earlier stage. That's why there was this painstaking examination as to when the loss first occurred on each defendant's land, or each potential claimant's land.
Yes.
So that has been, as I understand it, sort of common ground, at least for the purposes of the present arguments, in the sense that you're not running a limitation defence in a case where the land was first polluted.
That's right.
Even though the wrong had ceased to happen at an earlier stage. Because you accept the basic principle that the cause of action must be complete before time starts to run.
Yes, I accept all.
And in a sense, that's what Darley is saying, isn't it? That looking at this particular subsidence, the cause of action isn't complete till it happens.
That's right.
But once it's happened, it doesn't matter how long previously the wrong was done, as long as there's the relevant causative connection.
Accept that.
Yeah.
Lord Goldsmith, can I put this to you? I'm just anxious to know what you see as the case that you are trying to deal with, given that the declaration of Mr. Justice Stuart Smith was confined to continuing nuisance.
Yes.
So the point I'm putting to you is, you might see the case being put against you simply that you have to defeat the idea that there is a continuing cause of action day to day.
Yes.
But, as I understand it, we also have to deal with, and you see your case as having to deal with, a cause of action that could accrue at completely distinct stages because there might be separate, fresh damage. Is that right? Do you see yourself as having to deal with both?
I think I do accept that, but the important point is, all we're concerned with, as my Lord said at the outset, is there a continuing cause of action? Is there a continuing nuisance? Because otherwise, limitation has run. Subject to them, and they tried to get round it by saying concealment, by saying different dates, and that's the point of the date of damage judgment. And the hearing, the 4-week hearing, was can they show that actually there was fresh damage, or there was at a later date? Because they'd said, oh well, my Lord has said in the judgment that the damage would have occurred by the end of 2011, or within a few weeks at most. And that's what we were testing. And they failed miserably to show that it was. This is why this is really...
So there is no fresh damage possibility?
No, because factually it's not possible. That's what Mrs. Justice O'Farrell tested.
Thank you.
Or was tested in front of her. And really what we've been dealing with was the argument that Darley is a continuing nuisance case, and therefore that somehow helps the appellants. In our submission, it doesn't.
Could I say that I think, like Lord Kitchen and I believe Lord Reid, would be assisted by some submission as to when does damage become new damage for the purposes of a new cause of action. I mean, it's related to the points made in Darley about the principle that when you've got a cause of action, you have to bring your claim for all the damage associated with that cause of action, which actually is a very important principle, because otherwise a claimant could say, as Mr. Sietler was rather suggesting, or might have been suggesting, well, with the flood, the wood will only rot 10 days later, therefore I'll take the 10 days as
he had every opportunity to make that case.
I'm just asking for assistance in terms of how we should analyse the law. If the law is to be analysed, for instance in Darley, that there's a new distinct damage, loss that has occurred, how does one draw the difference between the first initial loss, because we know usually, if a house has been flooded, you can get compensation then and there,
yes,
in principle, for the rotted wood in 10 days' time.
Exactly.
But that wasn't the case as it was analysed by the majority in Darley, and indeed it seemed to me that was really the difference between the minority and the majority in Darley as to whether everything had to be claimed right at the start, even though the loss wasn't known. So the majority said no, there's some fresh damage, and then you can put that fresh damage together with the initial excavation, and you've got a new cause of action. But certainly I would be assisted. I understood my Lord Kitchen to be asking the same question. Well, when does one know whether one's dealing with new loss?
The answer I'm going to give will appear to be very unhelpful, but it is the common law answer. It will depend on the facts. And you could have fresh damage, as my lords say, the majority in Dali thought there was, because there was a further letting down of the surface. My lord is not asking me whether that's continuing nuisance. My lord's asking me whether or not, how do you distinguish whether fresh damage gives rise to a new cause of action or not? I suspect there may be cases where it'll be subject to a degree of doubt and appreciation by the court of what the facts actually are. In personal injuries, it's normally not a problem because there's one injury.
Well, exactly. Quite often you have an injury and you have an injured body or
Yes.
injured land or whatever it may be, and there may then be consequential losses which are all attributable to the injury.
Yes.
But that's not Dali.
Because in that example, the person injured, the initial act is the tort, the battery on the person. But the House of Lords went out of their way in Dali and other cases to say the extraction of the coal, though that is critical to the subsequent letting down, is not itself wrongful. So
I think what I'm wrestling for, I do beg your pardon.
Sorry, go on.
What I'm wrestling for is how does one distinguish one disturbance for lawful enjoyment of the owner of the land from another? When does a new disturbance take place? Is it when the oil has encroached onto a new island, or is it when the oil has moved further across the first island?
No.
Or is it where there is an entirely new and distinct disturbance? And how are we, as a matter of principle, to separate these different kinds of cases?
Well, my submission is that you've got to look at what is the act which is said to be wrongful, first of all, and what is said to be lawful is the release of the oil into the sea. That happens once, over 6 hours, whatever it may be. The consequences of that may take longer to come about, unless you have the particular circumstances, like in Dali, of the letting down of a surface because of an absence of support. You've only got one cause of action. And if they had succeeded in demonstrating...
But I think that's what we're pressing you on. Is it... I mean, you might be right, but why is it just one cause of action? If on a Dali-type analysis you can point to, let's say, the oil finally seeping through to the far side of the island, and you say, well, that's new loss in the Dali-type sense, then that's a new cause of action, and limitation for that runs from then. How does one tell when a discrete element of loss has occurred so that you can sue? You drew attention, I think rightly, to the use of the words damages in solido in the American case. The point being made there was you've got a cause of action, you can sue for all the loss in relation to that cause of action in one go.
Yes.
That covers what my Lord Reed was putting to you about the personal injury, where you get the consequential losses for your broken leg, which is future loss, but that doesn't extend the limitation period until whenever you will actually have suffered that, because you can collapse it all and claim that damage all in one go. And indeed, you have to claim that damage all in one go.
But yes, but what we're here concerned with, my lords, is whether or not there's a new cause of action at some stage after the date of this oil spill.
Yes.
Well, and it's because it is a continuing cause of action, so alleged. And this is why I identified the issue, as I tried to do in my introductory remarks. The allegation is the presence of the oil on the land is a continuing cause of action. They say the presence of the oil on the land is a continuing cause of action. That's why it continues, not because there's fresh damage, despite Mr. Siegler's interesting, completely hypothetical observations about wood rotting.
Yeah.
They had every opportunity to show something else, and they failed.
Looking at the examples that were being put to you a moment ago, if the oil arrived on one beach on day 1 and arrives on a different beach on day 10, then one only has to imagine the beaches being in different ownership.
Yes.
To appreciate that the limitation period for the damage to the second beach will be 10 days, within 10 days later.
That's accepted.
And that's why we had the date of damage hearing, because Mr. Dunning said orally on the 19th of September, oh, it may be some owners suffered damage at different dates.
I mean, is a possible way of looking at this through Dali spectacles that the second subsidence in Dali was a fresh damage for the purpose of giving rise to a new cause of action in relation to that damage, because it arose from a second subtraction of support by the defendant's scene of the plaintiff's land above it. Because what happened in the second substance, it wasn't something that happened entirely within the claimant's land, it was a collapse of the defendant's workings caused by partly caused by what was going on next door, partly caused by a lack of pillars or pit props. Now, here, by contrast, it might be said that although the oil, once it arrives on the land of a particular claimant, it all arrives at roughly one time, it goes on causing loss of crops, dying off of shellfish year after year after year, but those aren't fresh damage, as I'm putting to you as a possible analysis. That isn't fresh damage, because it's all continuing harm caused by the continued existence on the claimant's land of the original patch of oil that arrived there on that relevant date. It's not a new invasion of the claimant's land. It's continuing year-on-year harm caused by the original invasion of his land by the oil.
My Lord, I'm getting anxious side remarks because of the time, which is what we're worried about. But I want to deal with my Lord's question. But we're not simply concerned with is there continuing damage. That's my observation. And there will be cases where you need the damage in order to establish the cause of action. Actually not necessary here, but maybe for individual landowners it may be. I don't know, but they had the opportunity to show that, and we know that no oil actually reached anybody's land much after the beginning of 2012.
Your submission is these are all very interesting theoretical points, but they have nothing to do with this case.
They have nothing to do with this
Because
case.
Mrs. Justice O'Farrell has ended the issue about fresh damage.
Yes, indeed, we wrote them a letter several weeks before this appeal saying this is all gone now, because of what Justice O'Farrell has said, and they said, oh, no, we want to argue it. Well, of course they're entitled to, and that's what's happening now. But in fact, they've all gone. And there may be interesting questions in all sorts of cases about is an additional aggravation of an injury, does that constitute fresh damage? Does it, if it becomes cancerous? I don't know. All of those things are possible.
Right. Now, we will endeavour to maintain a vow of silence and allow you to complete your submissions.
Which I hate, because, my lords, it means I can't deal with the points that the lords have. But I want to finish Dali, though, and I would invite my lords to go back to read the judgments, but there's an aspect of Dali which my lords haven't seen yet, which was then considered by the Court of Appeal and indeed by the House of Lords in a case called Homburg and Agrocen. And my lords have that starting at page 3808. That's certainly where Lord Justice Ricks deals with it. Paragraph 105 of that judgment. I'm not going to spend time discussing the facts. My lords can look at those later, but it mattered when the cause of action arose. And so they looked at Darley Main Colliery, and Lord Justice Ricks said at paragraph 105, the substance line of cases exemplified by Darley is an exception rather than the rule. In the light of Cartledge and Johnson and Pirelli and Oscar Faber, the standard rule for personal injury and damage and property is that progressive damage originating from one act or omission creates a single cause of action. The reason why the substance line of cases is different is probably because the cause of action in those cases is a continuing cause of action, so treated in Salmon and Houston. And he says this appears to be recognised in the speech of Lord Bramwell, who defined the cause of action as depending on not merely the removal of support, but the non-providing against the consequence. I keep on repeating that point myself. That is critical. It's the fault in not providing support and continuing not to provide support. Since the act of excavation is lawful in itself, it's a continuing failure to provide against the consequences which provide the basis of the wrong once damage occurs. So that once the damage occurs, then you've got a completed cause of action. But the fault is the not provision of support. Now, that analysis of Darley by Lord Justice Ricks was approved in the House of Lords by Lord Bingham and Lord Hoffman, firstly at paragraph 3846, sorry, page 3846. So many competing page numbers, I'm afraid, my lord. So Lord Bingham at page 3846, paragraphs 39 and 40, but particularly at 40, my lords can perhaps, if they very kindly would read that themselves. And then he says at the end of paragraph 40, he refers to the reasons given by Lord Justice Ricks, which he's content to adopt as his own. So that's the imprimatur of the House. And then Lord Hoffman, at paragraphs 90 to 91, and starting at page 3854, I invite my lords to read that, including paragraph 91, and the reference to Darley, particularly the statement that the decision of the House in Darley was an unusual case, but each letting down of the surface was a separate cause of action. And we would say, well, that's because you have the coincidence of a continuing fault and actual damage flowing from it. The actual fault being the failure to provide support. And at an early stage in these submissions, I respectfully submitted that to talk about continuing nuisance is not to conjure up some magic concept, it's just a cause of action which continues. And like all causes of action, you need to have all the elements of the cause of action present. And if they are present and are repeated and continue, you have a continuing cause of action, but not otherwise.
Can I just check what happened in this case? So did the limitation period run from the initial negligent stowage? Is that what happened here?
I'm told yes. I need to go back to the case. There's sense of that. Yes. I've got, I think, 10 minutes. I'm told 10 or 15 minutes. I'm going to deal very shortly with I need to deal with Rosa. I will do, but can I just say something very shortly about limitation? Because my learned friend has suggested that there's nothing about stale cause of action here, and Lords have got the point. Of course there is, particularly as you'd have to investigate what happened many years ago as to a number of features. I need to deal with Rosewell and Thompson. Now, the question there, whether the plaintiff could pursue a second action against the same defendant for continuing the interference in circumstances where the defendant had sublet the property to another person. It's a very short report.
Just remind us the page, please.
I'm sorry, page 5148.
Thank you.
Apologies. So
It was Rosewell and Pryor.
Yes, Rosewell and Pryor. So if I said it was Thompson, I'm coming to that next.
Yes,
I'm
right.
sorry. The point here is that the owner, though not an occupier, retained control over the property even after he'd let it to a third party, and therefore he continued to be responsible for the building, and the building was a continuing nuisance because it was obstructing the ancient lights and it had not moved. The building remained where it was. The question seemed to be who was liable, the owner or the tenant. But the court said, well, the owner remains liable. And that's why I referred to Minton Goods before, because that's the same point.
It's very difficult to know what the reasoning is in this very short report.
Yes,
but at the moment, I'm not sure that is the reasoning. He says it's not because he retained control, because he transferred it, that's the property, with the original wrong.
Yes.
And his demise, that's the original, his sublease, affirms the continuance.
I don't understand that.
Which doesn't sound like the retention of control.
Well, I'm supporting the result in the case. Well,
yes. Then you have to look at the further report of this case in the Thompson case.
Yes. Let's go to Thompson.
Find out what Lord Holt said.
And it's obviously unsatisfactory from my Lord's point of view, but from all points of view, to try to determine very important issues in relation to law of tort on the basis of such a exiguous report. We need to just then look at Thompson, which is not much better.
And page reference for that, please.
Just telling you, page 5448. Oh, it starts at 5440, I'm told. My reference is 5448. Let me take 10.
That's not the one.
5448. Thank you, yes. The facts are slightly odd. A building was erected under what's described as the superintendence and direction of the defendants in October 1838. The land on which the building was erected was owned by a corporation of which the defendants, we are told, were members. We don't quite know in what sense they were members, but they were members. I don't know if it was an incorporated society or what it was, but they were members. The building obstructed a neighbouring market, and the building didn't move, so that continued to be a nuisance. And someone was liable for that. The plaintiff sublet the neighbouring land and then sued in nuisance. And the defendants argued that they couldn't be liable because as members they were not technically in possession of or interested in the soil on which the building was erected. The company that owned the land was, and we see that at 5449. That defence was rejected by Baron Park, who found the defendants liable in nuisance. Now, there's no doubt that somebody was liable in nuisance because the building, which was obstructing the market, was still there. And it was on land which the defendants had something to do with. They said it wasn't them because they were only members, not actually the corporation. On the other hand, if we see at 5449, they superintended and directed the construction of the building, and they were clearly responsible, said the court at 5449, to the then owner of the market for the immediate consequences of their wrongful act. So these defendants were able somehow to direct the construction of the building as members of the company, and nothing changed. So why should they escape? The building is still there. Why should they escape liability? because they said they were technically not in possession of or interested in the soil on which the building was erected. I mean, using a non-fully legal context, it looks like the defendants may have been proxies for the corporation. And that's why they were liable, because they'd superintended it, they directed it, they were still in control.
Well, that's the question, isn't it? Were they really still in control? On the face of it, a lot of what's said would indicate that they weren't, but...
The focus seems to be on their being responsible for the erection in the first place.
Yeah.
Not that what might have been their control later on, but they happened to have plonked a building in a way that had a continuing effect, damage-wise, on Lord Lonsdale's land.
And having a separate company somehow interposed didn't remove that responsibility from them. Seems to be what the case is about.
But analysed in that way, I mean, that looks a bit more like Lord Burroughs' trespasser in Sedley Denfield.
Or Lord Holt's, who commits the first wrong, is liable for all the consequences. Which is what they cite in support of their conclusion. And the headnote does say that they were liable, or they had no right to enter upon the land to remove it. So that it seems to be.
Well, that's what they said, obviously. That's obviously what their claim was. Well, I mean, a lot of advice in this 2 minutes and I'm going to just choose that which I want to transmit to my lords. To read this case consistently, for example, with Sedley Denfield, one needs to understand that the control is the relevant factor. And it may be that these people, these proxies, had the control. They'd created the original nuisance, and they're still in charge. Apparently.
We don't know why the company wasn't sued. It was the owner of the land.
We don't know why the company wasn't sued. We don't know if the company was capable of being sued. We don't know if it's an incorporated company or it's unincorporated. Is it a livery company? Just what is it? So, my lords, I've somewhat rattled through that. I want to suggest, my lord, just in conclusion, I suggest there are sort of three fatal errors in my learned friend's submissions, and I just identify them and won't spend time elaborating them. The first, and it may be we've gone away from this, the repeated statement by the appellants that the nuisance is the harm. For example, paras 48, 58, and 144.2 of their written case. That's the first error. And your lordships have my submission on that. Secondly, they're wrong to suggest that a continuing cause of action only requires the persistence of harm. The fact that the oil remains on land, if it does, doesn't mean that the cause of action continues. There may be a cause of action, and you may be able to claim for the consequences of it being on the land today. But that's not the same as saying there's a continuing cause of action. And that, the Canadian and American cases show that very clearly. The third error, and this was picked up by Lord Justice Coulson, is to suggest that remediation and abatement are the same thing. And it's very important to keep that distinction in mind. Well, my lords, happy to try and deal with any other point that your lordship wants me to. Otherwise, we submit that this now is the time for this case, I don't mean this hearing, but this case to come to an end. We've had endless hearings on it. This is the final stage, and we respectfully invite your lordships to dismiss this appeal with costs.
Thank you, Lord Goldsmith. Yes, Mr. Seatler.
My lord, listening to my learned friend's submissions and of course listening intently to your lordship's questions of him, inevitably made me speculate about what were the real fundamental questions that your lordships were going to end up having to confront in their deliberations henceforth. And we back 3 horses on that. The first horse we back to win is this question. What is the damage that needs to be shown to constitute the cause of action in nuisance? That's the fresh damage point, and it encompasses Lord Burroughs' trespasser. The second question that we think your lordships will inevitably face is, are these claimants coming to this court to try to upend the limitation regime? And the final question we think will come in third is, what difference does the judgment of Mrs. Justice O'Farrell make? My Lord, let me deal with the first. My Lord, we saw yesterday the statement, and there are other statements like it, of Lord Atkin in Sedley Denfield, where he said it's probably strictly correct to say that as long as the offending conditions confined to the defendant's own land without causing damage, it's not a nuisance, although it may threaten to become a nuisance, but where damage has accrued, the nuisance has been caused. We're familiar with those statements. But hidden in that statement is a question. What is the nature of the damage that is enough to cause the nuisance? Now, my lords, in our application for permission to appeal, for your lordship's note, it's page 2348, we said that Lord Justice Coulson in the Court of Appeal erred in law in holding that the appellant's submission was wrong in principle to equate nuisance with physical damage or harm. And we said, well, actually, that wasn't the appellant's argument. That wasn't the argument. The argument in front of the Court of Appeal by the claimants was that the nuisance was the physical presence of crude oil and the toxic chemicals that it contains on their land. That's the nuisance. It's the physical presence of the oil. And that's distinct from two things. It's distinct, of course, from the source of the nuisance, a ruptured flow line, obviously, and it's also distinct from the loss and damage caused by the nuisance, which is the various matters complained of in the claimant's pleadings about loss and damage. And there's two English cases. It may have developed differently in other jurisdictions, as my learned and noble friend has shown. Lord Goldsmith's juries, it may have developed differently elsewhere. But there's two English cases which show that that is the right characterization of the pertinent damage. And the first one is the decision of this House in this court in Fern and Tate.
In what?
Fern against Tate.
Oh, Fern, yeah.
Tate Gallery case. If your lordships look to page 3574, in the judgment of Lord Leggett, paragraph 21, Lord Leggett says that in applying these principles, the first question which the court must ask is whether the defendant's use of land has caused a substantial interference with the ordinary use of the claimant's land. Now, Lord Leggett in Fern didn't speak of damage. He said that the first question is there a substantial interference with the ordinary use of the claimant's land? And the sheer width of what qualifies can be seen from the majority's decision as what was the nuisance in that case. What damage, in the sense used by my Lord Burroughs yesterday and today, what damage is suffered by the residents of the flats overlooked by the Tate's viewing platform? There's no tangible physical impact equivalent to flooding or an explosion. But what there is ongoing and persistent interference with their use or enjoyment of those flats. And it's that's sufficient to give rise to a cause of action in nuisance. And the same thing happens in the picketing cases. The same point can be made. The damage is the watching and besetting. And in our case, the damage is equivalent. It's the physical presence of crude oil and the elements it contains on our land.
You would say that Fern is a case of continuing nuisance?
Yes. My Lord, I said there were two recent cases, English cases. The second, which we've mentioned but not looked at properly, is the decision of the Master of Rolls the then Master of Rolls in Williams and Network Rail, which really does show the flexibility of the concept of damage in nuisance. If your Lordships would look at page 5014, at paragraph 39, Sir Terence Etherton, Master of the Rolls, says he'll summarise the present principles of the cause of action of nuisance. First, a private nuisance is a violation of real property rights. That means it involves either an interference with the legal rights of an owner of land, including a legal interest in land, such as an easement and a profit apondra, or interference with the amenity of the land, that is to say, the right to use and enjoy it, which is an inherent facet of a right of exclusive possession. So it's a property tort. And the key point for our purposes is at paragraph 42, at the bottom of that same page. Thirdly, he says, the frequently stated proposition that damage is always an essential requirement of the cause of action for nuisance, because nuisance is derived from the old form of action on the case, must be treated with considerable caution. Cites various cases, four of which we've looked at, and says it is clear both that this proposition is not entirely correct and also that the concept of damage in this context is a highly elastic one. Those words, my lords, we say are important. It's highly elastic. In particular, interference with an easement or profit apondra is actionable as a nuisance without the need to prove specific damage. Various cases cited. Furthermore, in the case of an artificial object protruding onto a claimant's property from the neighbouring land, Mr. David Hart, QC for Network Rail, accepted that the claimant has a cause of action in nuisance without proof of damage. And then the judgment in Kelson is discussed, and then at the final sentence of that paragraph, having discussed the Kelson case and Batten's case, Master of the Rolls says that in itself shows both the artificiality and elasticity of any requirement of damage for the purpose of establishing nuisance. Now, my lord, what happened in this case was Japanese knotweed grew into the claimant's land, but they did not have to wait until it physically started interfering with their property, because the mere presence of it, the simple presence of it on the land, interfered with the amenity value of the land. That's at...
There was immediate damage because its development value was compromised.
By reason of its presence alone. Absolutely, my lord, the presence of the knotweed imposed an immediate burden on the landowner because it makes it more difficult to develop. So there was a persistent interference with the claimant's property rights before the physical damage which would inevitably ensue. So the damage arises just because of the substance that is there on the claimant's land. And so we get to the question that my Lord Sales asked my learned friend this morning. How do you tell when the cause of action arises? The answer is when there's substantial interference with the claimant's land. And if damage isn't always required to be shown for a cause of action in nuisance, what does need to be shown? Answer: interference with the real property rights of the claimant. Nuisance is about the prevention of substantial interference with rights in land, so as to allow the holders of those rights in land to vindicate them. And, my lords, once we recognise that the damage element that's necessary to complete the cause of action is interference with the claimant's rights in land, there is no logical or legal reason why you would need to show fresh damage, whether by repeated cricket balls, repeated sewage floods, or the same oil spreading to new areas of the property, rather than continuing damage. And we can compare it in our minds to the case of, what we can compare in our minds is a situation where there's a series of small floods, and compare that to a position where there is one big flood. There's no reason to treat them differently, such that the smaller floods give rise to fresh causes of action day by day, and the big flood doesn't, if they have the same end result, a continuing interference with the claimant's ordinary use and enjoyment of land by the presence of floodwater. And that's the nuisance. And my lords, we say that's the explanation, that's the key to unlock Delaware mansions, because it's important to put the focus back on what the judge found at first instance in that case, Recorder Derek Wood. It's set out in Lord Cook's judgment at paragraph 8, it's page 3489. At the end of paragraph 8, a third of the way down the page, Lord Cook, citing the judge at first instance, records that all or almost all of the structural damage, which is the subject matter of the plaintiff's claim, had occurred as a result of the 1989 drought, not later than March 1990. If, which is not certain, some further cracking took place in the superstructure after that date, that cracking, in my judgment, was the further consequence of the 1989 to early 1990 damage to the foundations. And the implications of that are summarised in the headnote at page 3484. If your lordships would be kind enough to look just down, just at letter F, just above letter F. However, he dismissed the claim on the ground that the damage had occurred during the F Commissioner's ownership. Flex on.
Sorry, which page are you on? I beg your pardon.
My lords, I'm on page 3484, the headnote.
Thank you very much.
And I'm just above letter F. However, he dismissed the claim on the ground that the damage had occurred during the Commissioner's ownership, and F Limited had not been able to prove that any of the remedial work it carried out had been necessitated by new damage to the foundations during its time as owner. And when it says he dismissed, then it means the first instance judge. And that finding at first instance was the whole point of the appeal in Delaware. The judge at first instance found, as a fact, that there was no new damage in the period of ownership of the second owner, Flexer. Hence, he dismissed the claim. So, what then gives rise to the fresh causes of action which were the basis of the successful appeal in Delaware? Answer: it was the continuing interference with the claimant's property rights. That's made clear at page 3496. In paragraph 33, at the bottom of the page, it's the second sentence. It matters not, just below H, it matters not that further cracking of the superstructure may not have occurred after March 1990. Just as it matters not that my client's fish farms and drinking wells and shrines have not been hit by any fresh oil. These are all consequential matters. But rather, Lord Cook continues at the bottom of page 3496, damage consisting of impairment of the load-bearing qualities of residential land is, in Lord Cook's view, a nuisance. So, my lords, by parity of reasoning, interference with the crop-bearing qualities of agricultural land must also, in and of itself, be a nuisance. Residential land should be capable of bearing buildings. Agricultural land should be capable of being farmed. Fish farms should be capable of breeding fish. The nuisance is the interference with the use of the land and the rights to the land. So, in both Delaware and in our case, although the consequential losses may have occurred by reason of the initial impact of the nuisance, the cracking in Delaware, or the eradication of fish stocks in our case, the interference with the ordinary use of property continues. And that's what gives rise to fresh causes of action for a cost of cure remediation claim as long as the interference continues. So when we say nuisance is the harm, and my learned friend takes against that, what we mean is that a nuisance is the interference with the claimant's property rights. That doesn't need fresh wrongdoing or the defendant's control in order for it to continue. And that, my lords, is why we say that my Lord Burroughs' example of the trespasser from Sedley Denfield is so potent. What Lord Burroughs' trespasser example shows is that it can't be right to say that there must in every case be fresh wrongdoing for causes of action to accrue. The trespasser had long gone. It would have occurred in Darley if the lease of the mine had expired. It also can't be right as a result of that trespasser concept. It can't be right to say that fresh causes of action can never accrue where the defendant no longer has control of the hazard which gives rise to the nuisance. The example shows that those two core planks of the respondent's theory of continuing nuisance just don't work. So we do say that my Lord Burroughs' trespasser, as much in this case, contains a hidden question. And the hidden question is, what further consequence of the original causative act, creating the nuisance, needs to be shown for a fresh cause of action to accrue? And the answer is, what needs to be shown is further continuing interference with the claimant's property rights. My Lord Kitchen observed in relation to Darley yesterday that separate disturbances were a key element of the reasoning. My Lord, we agree that separate disturbances are key, but not because this is fresh damage in 1882. That's not the gist of the cause of action. The gist of the cause of action is that the subsidence gives rise to a claim in nuisance because it's a continued interference with the use or enjoyment of land. The first cause of action was for the interference with the use of enjoyment in 1868. The second cause of action was for the interference with the use and enjoyment in 1882, caused by what happened in 1868. So the significance of the separate disturbances is that a cause of action in nuisance for interference with the use or enjoyment of land arose in respect of each of them. And it follows from that where the nuisance is continuously interfering with the use or enjoyment of the land, fresh causes of action continuously accrue to die in diem in respect of it. And the final point is really this, that the nuisance, because the nuisance is the physical presence of oil and the toxic elements within it on the claimant's land, that illustrates the key difference between nuisance and negligence, a point raised both by my Lord Sales and my Lord Burroughs. The nuisance is the interference with land. Negligence is about the duty of care, what care was taken, and anybody can claim it. In nuisance, a claim is restricted to those who have an interest in the land. The conduct of the defendant is irrelevant in nuisance, but it's critical in negligence. And that's why in nuisance damages are calculated by reference to the impact on the land. You can't recover damages for personal injury in nuisance. So, my Lord, continuing nuisance is not what my learned friend Goldsmith sought to say, sprinkling magic dust over just what's another tort. Not at all. Nuisance is a property tort designed to protect the claimant's use and enjoyment of land, and when that's interfered with, that's when it's constituted. And all of the distinguishing features with negligence actually drive that home. And that's what we think will be the first question that your lordships will face. The second question that I think your lordships will face is, are these people coming to upend the law of limitation? We say, well, no. We're applying Darley, and Darley has been the law since 1868 without it having a radical effect on the law of limitation. And Darley is important. We say that it's not a question of whether Shell could have a liability as long as the effects of its pollution remain unremediated. That's not what this is about. We're simply applying Darley. And what Darley is about...
I'm right in thinking Darley wasn't dealt with lower down. Is that right?
My Lord, this is what happens when you bring property lawyers in. They tend to look at property cases. I think my Lord may be correct. I think my Lord may be correct. What we say your lordships can take from Darley is this: if the original act or omission remains the operative cause of a continuous harm, there's no need for a further act or omission. What Darley shows is that you don't need a second act or omission on the part of the defendant for a second cause of action to arise, where the first act or omission causes a subsequent interference. So, if that's right, the question is, to answer my Lord Burroughs' question to my learned friend from earlier today, if that's right, why should there not be fresh causes of action where every day, where the first act or omission continues to cause a fresh interference each day with the land? And in Darley, there is no fresh act by the defendant. There is by Cooper, but not by the defendant, that forms the basis of the reasoning of the majority. And what Darley says, when you look closely at the reasoning of the majority and the basis of Lord Blackburn's dissension, is that even if there is a continuing omission in relation to the quality of support, the original excavation is still capable of being the operative cause of the substantial interference to the claimant's land. In other words, Darley is saying, if the original act remains causally operative because it causes continuous harm, that's enough. My Lord Goldsmith referred, as we expected, to Lord Justice Ricks's treatment of Darley in the negligence case, and the House of Lords not saying that was in any way wrong. If your lordships do look at the judgments of Lord Justice Ricks, we say with respect to him that his analysis doesn't actually reflect the reasoning of the majority. One has to look quite closely at it to pull it out. If we look at Lord Bramwell, page 3444, right at the bottom of the page, it gives a pretty strong clue to the way he was thinking. He says, the last line of the page, of course one can see the danger and inconvenience that will follow. And then there's this sentence, my lords, which we think is pretty revealing. This damage accrues many years after the defendant's act or omission which has caused it. If my reasoning is right, many years hence there might be a further action from some further subsidence. He wasn't reasoning this on the basis of a continuing omission to leave support. This damage accrues many years after the defendant's act or omission which caused it. And then if we can look at Lord Halsbury, similarly at page 3431, in the middle of the page, the sentence beginning, "I cannot understand," which is in the paragraph, third sentence of the paragraph in the middle of the page. "I cannot understand why every new subsidence, although proceeding from the same original act or omission of the defendants, is not a new cause of action for which damages may be recovered." So again, like Lord Bramwell, Lord Halsbury is talking about the new subsidence proceeding from the same original act or omission.
Sorry, can you just give me the page reference for that again?
Yeah, my lord, forgive me, page 3431.
Thank you.
And it's the reference to original act or omission is in the second sentence of the middle paragraph, just halfway down. Further down that same page, 3431, Lord Halsbury says, he talks in the final paragraph about Robotham and Wilson, and then he says in the next sentence, "The defendant has originally created a state of things which renders him responsible if damage accrues." Originally. He's reasoning it by reference to 1868. "If by the hypothesis the cause of action is the damage resulting from the defendant's act or an omission to alter the state of things he has created, why may not a fresh action be brought?" And these two passages suggest that Lord Halsbury, as well as Lord Bramwell, was talking about 1868, not continuous wrongdoing by a continuing omission to support. Now, Lord Fitzgerald is slightly harder to read, but we think it's possible. If your lordships go to page 3447 in the speech of Lord Fitzgerald, and in the halfway down the page, in the middle paragraph, he says, "It will be observed on these admissions that the partial subsidence of 1868 had practically ceased, and that a fresh creep and subsidence took place in 1882, which would not have taken place if the defendants had left sufficient natural support under the plaintiff's land, or we may add, had substituted adequate artificial support." And my lords, we read the phrase "had left" or "had substituted" as connoting a historic omission. And that fits with the next paragraph, because the next paragraph starts with, "There can be no doubt that though there has been no act or of commission by the defendants since the completion of the excavation of 1868. On the next page, 3448, Lord Fitzgerald again is concerned with the conduct of the defendant in 1868. He says in the second paragraph, "We have to consider what the cause of action in 1868, whether the cause of action in 1882 is one and the same cause of action of 1868. And then, just above halfway down the page, at the end of the paragraph beginning this appeal, he says, "The question here is not whether the original act of the defendants was innocent, but whether the defendants have occasioned damage to the plaintiff without any inevitable necessity." So the question for Lord Fitzgerald, the third Law Lord, was about the original act. So, read in the context of his judgment as a whole, the omission that Lord Fitzgerald had in mind on 3449, when he says the defendants permitted the state of things to continue without taking any steps, in the context of his judgment, that was not a continuing omission, but a one-off omission which occurred in 1868 when the defendant finished the excavation works and failed to put in support. Now, my lords, we have Lord Halsbury, Lord Bramwell, Lord Fitzgerald, all appearing to talk only about 1868 cause of action, and Lord Blackburn is so clearly on the other side of the fence. If we look at Lord Blackburn at page 3442, yes, at the end of his judgment, near the 4 lines down near the top of the page, he says, Lord Justice Bowen says that, applying the reasoning in Whitehouse and Fellows, it seems to me that there really has been not merely an original excavation or act done, but a continual withdrawal of support. And then he says, if I could take that view of the facts, I should agree in the conclusion, but I cannot take that view of the facts. So what we have, therefore, is that actually this was common ground between all 4 law lords. And what divided the majority from the minority was whether this was fatal to the claim. So, yes, there was a lack of support from 1868, but the majority judgments are not reasoned on the basis that that's the cause of action. The majority judgments clearly proceed on the basis of a finding that the cause of action arose in 1868. And that's been the position in law since 1886, and the limitation sky hasn't fallen in since then, and we say it won't in future either. There's nothing new about what we say.
On page 3448, in the paragraph you took us to a moment ago, the 3rd paragraph on the page, Lord Fitzgerald says that this appeal represents a class of cases peculiar and exceptional, and the same point was made by Lord Bingham and Lord Hoffman in the passages we were taken to in the Homburg case. And Lord Hoffman identified there what was the peculiar and exceptional circumstance, which was that the cause of the damage was not a wrongful act, so that there's no question in this situation of continuing wrongdoing, or even the continuing consequences of wrongdoing. There is the cause of a damage is not a wrongful act. That is an unusual form of an unusual situation in tort, and it explains why you have to focus on the damage itself as the critical feature of the cause of action.
My Lord, that's your Lordship has hit upon one of the essential differences between Homburg, a negligence case, and our case, a nuisance case, because in negligence, wrongdoing on the part of the defendant is critical. And as I started with saying yesterday, one of the remarkable things about nuisances is that the act itself need not be unlawful. It can be desirable, like playing cricket or growing trees. And that's one of the differences. You don't need wrongdoing in order for there to be a nuisance. It doesn't have to be an unlawful act, usually isn't.
I'm not sure what Lord Hoffman was saying you don't need wrongdoing. I thought he was saying the wrongdoing consists in the abstraction of the support which one person's land is entitled to have from the land either underneath it or next door to it.
Lord Hoffman
was saying,
yes,
it's an abstract. The wrongdoing lies in the abstraction of support.
Yes, but that's because he needs to look for wrongdoing in a negligence case. We say nuisance has gone off in a different direction, even since Professor Newark's article in 1949. Nuisance has gone off in a different direction.
Well, he says, it's on page 3854, paragraph 91. He says Darnley was an unusual case in which the cause of the damage, digging coal underground, was not a wrongful act. It gave rise to a cause of action only insofar as it let down some part of the surface. So there was no unifying element in the cause of action. Each letting down of a surface was a separate cause of action.
Yeah.
That's what he has to say about it.
Yes. Yes, well, with respect, we say that doesn't actually reflect. That certainly reflects Lord Justice Ricks's reading of Darley, but we've gone back to the source, and we think it doesn't. We think if you look at Darley, it's about 1868.
Can I just look at your submission that this isn't driving a coach and horses through limitation? The essence of your case is that for as long as the interference continues, if you like, a new cause of action with a 6-year limitation period arises every day. So as long as the oil is there, I've got a new cause of action every day when the oil's there. That's my understanding of your position.
Yes, and we can claim for 6 years back.
So, yes. So, suppose it was a radioactive substance with a half-life of, let's say, 1,000 years, and it couldn't be removed. Does that mean that the claimant can sue in relation to it for 1,000 years, even though the effect on his land is exactly the same on day one as it is on year 999, namely, nobody can use the land? I'm using half-life as a stage at which after which it may cease to have that consequence.
Yes, and that's a great deterrent to allowing radioactive waste.
I'm sure it is, but
yes, one could, but there'd be no purpose in waiting 1,000 years, because once one has 6 years worth of damage, one can claim for that 6 years back, as it were.
But you could do.
You could do in theory.
But surely, if it really did happen like that, you claim for the complete damage to your land, extending all the way into the future.
Yeah.
And you get damages reflecting that loss.
Yes, you would. Yes.
But if you could do that then, surely you can't wait, because you've got a cause of action in relation to which you can recover for all that loss. And you should recover for all that loss in one go in the relevant limitation period. And that was the point made by Lord Justice Fry, with which Lord Blackburn was emphatically agreeing, that where you've got a cause of action, you have to bring it and claim whatever damage is available to you at that time in one go. And that actually fits not just with theories of limitation, but theories of case management and abuse of process and everything else.
And my lord, in Darley, that consequence is considered. Those very consequences are considered in the passage where I can't remember which Lord.
No, they are. But the reason I'm pressing you on the radioactive example is it might be said that the radioactive example shows that there is, if you like, a single event of damage, the compensation for which will cover future consequences arising from that single event, but you have to sue within a limitation period judged by reference to the initial inception of that damage.
But it's continuing damage. It's
all right, maybe we'll go round in circles.
Yes,
but
it arises to die in DM.
You say, but it's damage which is compensable as from the date of the inception of the spill or whatever it is.
It is. It is too. Yes. One has the chance. One has the opportunity to choose one's period for claiming.
So you would just carry on being entitled to claim, but you say only for the previous 6 years of damage. Is that right? Or whatever the limitation.
Yes.
Whatever the limitation period.
Whatever
is.
the limitation period is. Say it's 6 years, as it would be.
Yeah.
Then you'd be able to claim for 6 years worth of damage, of it being on your land.
And that carries on and on, so every 5 years, 364 days, you still have an entitlement, and then you wait again, and then you do get another 6 years, and that's how you see it happening.
Because, my lord, if in the next door land there was an area which was contaminated by radioactive waste, which had a much shorter half-life, and the damage was over in 2 or 3 years, the interference with the land was over in 2 or 3 years, but then there was another radioactive leak, also of a short half-life, so there were 2 instances. Why should it be different? Why should it be different in one situation where there's continuing interference with the land from a situation where there are 2 separate interferences with the land? Why should the first person be in a worse position? If there was a second leak, it would be the same effect. And yet both involve a continuing interference with the claimant's land. And my lord, that's why it all comes down to it being a property tort, and it's why the interference with the land is what counts, not the conduct of the defendant.
Well, I think you might say they're all in the same position. That the claimant has to sue when the cause of action first accrues, and it isn't the continuing interference with the right that continues. So they're all in the same position. They've all got an accrual of the cause of action at whatever time that occurs, and then they've got their limitation period. And if they don't choose to take it within the limitation period, so be it.
Well, but my lord, on my example, which echoes your lordship's trespasser, the second leak could come from a different defendant. Could be the responsibility of a different defendant. So why should these 2 entities, why should these 2 claimants be treated differently? They've both got continuing interference. My lord, I wonder if I might
have to deal with Mrs. Justice O'Farrell's.
I'll be very, very quick. 3 very quick points. The statement of facts and issues, paragraph 48, states that the parties have agreed that page 3030. Yes, paragraph 48, second sentence. It's been agreed that in any event, the issues of fact and law to be determined in relation to the date of damage issue are not relevant to the issue of law that arises for determination on this appeal. Now, there's a reason for that agreement. The reason is because actually, at the date of damage hearing, Mrs. Justice O'Farrell was focused on a different question. She was focused on the question of whether communities located further inland when they first suffered damage as a result of this spill in 2014 or 15 due to delayed migration inland of the oil. And the evidence available in respect of those inland communities doesn't tell us anything about the evidence that might be available in respect of communities on the Nigerian Atlantic shoreline, which Mr. Justice Stuart Smith held would first have been impacted within weeks or months.
I remember noticing place names in Mrs. Justice O'Farrell's judgment, which corresponded to place names mentioned in the witness statements by the claimants.
My lord, there may have been 1 or 2 overlaps, because the claimants did also own land inland, yes, own land inland. Yeah. So that's where there was an overlap. But the focus of Mrs. Justice O'Farrell's inquiry was temporally and geographically distinct. The shoreline communities, we say, are the ones that have suffered the continuing nuisance. And we're not asking your lordships to draw any inferences from those statements, my lords. I only referred to those page numbers because my lord the president clearly wanted to know something about who these individuals were, and that was the easiest way to get to that. But that's been agreed for good reason to be a quite separate exercise. My lord, I don't know whether I can help you, lordships.
Has that got you to the end of your third point?
My lord, the only thing is I think I've agreed with my learned friends that we make the joint application in respect of costs, that it follow the draft judgment.
Yes, that's understood.
My lord, if your lordships are willing to do so, I wonder if your lordships would direct that the parties provide written submissions 21 days after the hand down of the written judgment.
Yes, in relation to costs. On costs, and indeed the form of our order. Yes, we would normally, well, we would normally, to be perfectly honest, I normally leave that to our registry people. So you'll no doubt be contacted and given whatever their standard time is to put in submissions on costs. Now, does that then leave us with the provisional points?
Yes, it does. And
Yes.
it leaves us doing that at 2 o'clock,
Yes.
so I assume, and as I've said, from our point, Dr. Blake will take the burden of doing that.
Yes, very well. 2 o'clock.